Good morning and welcome to the Minnesota Association of Townships Town Tuesday. Today, by request, we are going to be talking about weed inspection. Uh, so, uh, I thought I would just say a few words as sort of a general overview of this one. Now, if you've come to these before, if you've heard me talk about um, the way the legislature has chosen to sort of organize statutes. One thing you'll hear me complain about is that sometimes they have you play a game of hide and seek to find out what it is that you're supposed to do. Well, weed inspection is probably the specific worst for this topic that townships deal with. So this one's one that's worth sort of thinking about here. Okay, so the basic overview comes from Minnesota Statute Chapter 18. Which is pretty far from our usual chapters, 366, 365, 368, and so on. But so the basic rule comes from Minnesota Statute 18.80 subdivision 2, and that provides that supervisors of each town board shall act as local weed inspectors within their respective municipalities. As part of that, you are supposed to examine all lands to ascertain if section 18.78, the one that says every landowner must manage noxious weeds or destroy noxious weeds, as being complied with. See that the control or eradication of noxious weeds is carried out in accordance with the notice procedures, and issue permits in case of folks who need to travel. But of course, there's always more, and it is hiding in some weird spots. So on top of those duties, which are under the statute that's listed duties, there are these other ones that are kind of hiding out in weird places. So you're supposed to attend an annual training. Now, this can be either law enforcement training, it can be that portion of the County Township Officers Association, or it can be by taking a correspondence course or other course approved by the Commissioner of Agriculture. Now, this one is hiding in Minnesota Rules 15050758. You're also supposed to report annually to the county inspector about, quote, their activities, unquote. So as a board, you're supposed to just write a little report about what it was that you did that year for each or with respect to noxious weeds. And you're supposed to pass that along to the county inspector, who then in turn passes it along to the state commissioner of agriculture. Finally, there's another one that's hiding out in a completely different place, which is independent of our duties as road inspectors. This one is imposed on us through our duties as the road authority. And that is, the road authority must, quote, cut or otherwise destroy or eradicate all noxious weeds in their respective right-of-ways, often as may be necessary to prevent the ripening or scattering of seeds. This one's hiding in Minnesota Statute Chapter 160, specifically Minnesota Statute 160.23. So that's not one that you necessarily know, even if you knew to look at the actual weed inspection chapter. Okay, looks like there are some questions, but that's it's being handled in the chat there. Great. All right. So what powers do we get? We talked about our duties. What powers do we get? Well, it's pretty straightforward. Local weed inspector, quote, may order the control or eradication of noxious weeds within their jurisdiction. There's a process to this. It mostly comes from Minnesota Statute 18.83. And it sort of begins with, so that the county is supposed to issue an annual notice saying everybody must control these weeds. And then if somebody doesn't comply with that notice, the local inspector can, if they discover that, they are to issue a written notice of noncompliance. That notice has to include specific instructions on when and how the weeds in question are supposed to be destroyed. It has to be served on the landowner. You can do it either through certified mail, or you can do it by the same process that you would start a civil lawsuit. That is personal service. So, civil certified mail is going to be a lot cheaper. But if you're worried about proving up that somebody actually got this thing, if you're expecting to have to litigate about it, you might choose the personal service one, just as a way to be extra clear that this is a serious matter and there are going to be consequences if you don't comply with this. So what happens after they get that notice? Well, they can appeal if they want. And they have one of the shortest periods in law to actually do that appeal. So this is from the statute itself. They get a 2-day window to appeal to the county appeal committee. And if they don't like the decision that they get from the county, then they can appeal that to the district court. But once that's done, so if the owner fails to comply again, and when it is necessary to prevent the maturation or spread of noxious weeds, all or part may be controlled or eradicated after the appeals committee takes a look at it and agrees. We also get a few little incidental powers with respect to this. So we can contract for the eradication. It's nice to have a fairly explicit grant of authority for that purpose. We get our expenses back, at least partially. So the expense incurred by you in your duties as a local weed inspector are a charge against the county. This one is provided for in statute. Now you have to verify your expenses and you have to itemize them. And the county then gets to turn around and reimburse itself through the landowner by putting that amount of money, by charging it to them or putting it on their taxes, either one. But you are entitled to the expenses that you're incurring as a result of these duties. Some of the more potentially useful things to know about this is that you do get certain protections from various other legal schemes, right? You get protection from trespass action. So obviously, as part of your duties, you do have to go see if there are weeds out there. And people get very sensitive about people going onto their land, of course. So you have some protections against folks who are trying to start a trespass action against you. Now, there is a specific and separate authorization to enter upon land. So there's the trespass action protection in 18.79 subdivision 3. And there's another one that provides express authority to enter upon land in 18.83 subdivision 6. That one's a little bit more limited. I don't like it as much. So that one requires that the landowner already have received notice and not comply with it. So it's not particularly helpful during the inspection phase of your duties, right? It's only useful when you already know that there are weeds that are not being controlled on that particular property. But it is nice to have a sort of belt and suspenders extra level of protection, right? So that's potentially helpful and one that you should possibly know. Now, I am familiar with the case. We started out this talk by talking a little bit about how this is kind of tucked away in a weird area of statutes. This is the sort of thing that I would not expect most attorneys to be aware of. Now, folks who do agricultural law, yeah, they're probably going to know it. But even there was a case down in Yellow Medicine County when I first started at the association a couple of years ago now, in which the local county attorney wasn't aware of these duties and actually charged one of our supervisors with trespass. Now, my understanding is those charges were dismissed because obviously this guy had a positive duty to go eradicate weeds, and he can't very well comply with the positive duty unless he has the right to go look, right? On top of which we have these protections from trespass. But I think that was just a case of the county attorney not knowing what this statutory scheme was, not being familiar with it, and a little bit of overreach there. So it is something to know because you want to be careful and you want to be able to point this stuff out if it ever comes up, right? And then, of course, you also get a nice little protection from damage actions arising from your duties. So you have some level of protection. If somebody says, hey, they came onto my land and they damaged it while they were getting rid of these weeds, you have some protections against that. Now, if you're anything like me, one thing that you always ask when dealing with a statutory scheme is, hey, look, this looks like kind of a pain. What happens if I just don't do it? And there are penalties provided for. So there are provisions that require us or that sort of incentivize us to fulfill our duties as local weed inspectors. And these are, again, sort of hidden in some weird areas of law. So there's Minnesota Statute 18.81, Subdivision 3, and then Minnesota Rule 1505 again. And there's basically, there's a process. So first, if we don't perform our duties, then the county gets to issue, or the county ag inspector gets to issue us a notice providing us instructions, quote unquote, on how and when to do the duty. If that's not effective, and they're supposed to put a time limit in it, if that's not effective within the time limit, then the county can do it themselves and bill the township. If the township fails to actually pay that bill, then the county is authorized to just withhold it from the levy later on in the year. So this is the kind of thing that you don't want to mess with this too much, particularly if it's looking like it's going to be expensive, because if you do it, you get reimbursed by the county, whereas if you don't do it, you get charged. So that can potentially be a substantial expense, depending on how much they end up spending on doing the actual control measures. Now, of course, none of this is very helpful unless you have an actual list of what weeds are and are not, quote unquote, noxious. And that list changes. It's not super helpful to just detail it right here because it's going to change year to year. So the place to go is up on your website, is up on your screen there. https://www.mda.state.mn.us/plants, insects, Minnesota noxious weed list. Now, if you are anything like me, you can just Google Minnesota Department of Agriculture noxious weed list. That'll get you there. But if you prefer to go directly, so there's the address on your screen right there. Now that list does change from time to time, so do check. And if you want more information on this topic, which is sort of, I threw a lot at you here, and there's a lot of potential for if you missed anything, if you want to go over anything in more detail, we do have written guidance on this. So in the Minnesota Association of Townships Information Library, look for document TD 4000. Just put that in the search bar in our website. That'll take you there. Or if you prefer to navigate through clicks, it's Information Library, then Town Duties, and then you're looking for TD 4000, which is specifically about noxious weeds. Okay, Leslie, thank you for throwing up the actual hyperlink there. Appreciate it. Okay, folks. So that is the long and the short of it. Does anybody have any questions?
Graham, I don't have a question. I just kind of want to jump in and share something here really quick. This is Heather Tidmore. I'm the director of MADIT, and I just wanted to let you guys know from the MADIT side, the name of the coverage is flipping to public employer liability. But on our end, if you guys do get caught up in this, like the yellow medicine, the supervisor did ultimately have to go to court, did have to defend himself, and the coverage in our right now it's the E&O, but that public employer liability will cover 85% of your cost to defend yourself once you receive either those dismissed charges or a not guilty decision. So once you're vindicated and proven right, then let us know and we can get you back some of the costs that it costs for you to go do that.
So the question is with respect to what if residents don't want us on their property looking for weeds? The answer is that we have a positive duty to make sure that these things are controlled, and we do have protection against trespass action. So we have the right to go look in this context. Now, you want to be very careful about that because, of course, you can end up in these disputes, and quite frankly, people get very sensitive about people going onto their land. So none of this is worth getting into a potential altercation here, right? But yeah, we do, strictly speaking, have that authority. Now, if you're dealing with somebody who's absolutely refusing positively to let you on your land to check, this is something to bring up with the county inspector and potentially local law enforcement to just sort of game through a plan about how it is that you want to approach this problem. Right. I think that the county in particular is going to have a lot harder time charging you if you're dealing with a genuine safety issue and you have planned it out with county employees how it is that exactly that you're going to attack this problem. But Yeah, so that's one of the reasons that you do want to be aware of those statutes that give you protection from trespass actions. Yes, lots of residents have guns, and lots of residents really don't want you on their land. And like, look, it's better to get charged by the county than to get shot, right? I'm not going to advocate for anybody to take risks that are unreasonable, but that's the sort of thing that I just can't really, the personalities involved in your local township better than I do. So if you feel like you're in potentially one of those situations, I would advise talk to the county inspector, talk to the county sheriff, talk to the county board. Hey, look, we have this problem. We have a duty to do this. We'd like to take care of it, but we think this guy might take pot shots at us if we do. So it's a hard situation to be in, but there are steps that you can take to just kind of minimize your risk if you end up in that situation. The question is, can you pass this info up to the county? Farmers have laws prohibited people looking around. That's true. I would say in general, so the specific outweighs the general, and in this case, we have a specific permission for this particular purpose. Now, it is in one of those weird areas where people don't really know. Like, not that many people know Minnesota statutes, and the people who do know Minnesota statutes rarely deal with Chapter 18. Now, if you're dealing with somebody who's citing a law at you, you can cite a law back at them because you do have protection from trespass and a positive duty to make sure that this is getting controlled. Now, I know farmers are hard-headed folk who are very, very set in their ways, generally speaking. But I do think that there's a good argument to be made for why this is too. Look, these noxious weeds do genuinely damage agricultural land. That's kind of the point, right? So there's a good public purpose and a public purpose that benefits them as an individual to allowing this thing to happen, right? That said, yeah, don't take. I mean, if you feel like your safety's at risk, just no, don't do it, right? Question not related. Does the association have any information on placing a question on the November ballot for voters to become a city or staying a township? Thank you. Now, that is an interesting question. I am aware in general terms of the process to become a city. Now, I don't feel like I'm prepared to give you an answer on that one off the top of my head, but if you give me a call after we get off, I'd be happy to just sort of start pulling stuff and walk you through it. I don't think we have published guidance on that up on our website, but I do believe that we're in Chapter 471 and a few other places. There is some guidance on what that process is, what it looks like. Okay. Reno has some good advice here. When you're checking out the land, wear a reflective safety vest. If you can get have the township pay for some formal identification weed inspector, just so people know what you're doing and don't feel like you're just out there sneaking around trying to do something underhanded. And of course, checking in with the landowner is usually a good idea. If people know who you are, what you're doing, why you're doing it, you're going to run into less problems than if you just sort of wander onto somebody's land and you're wearing street clothes and they have no idea who you are, what you're doing. So yeah, there are ways that you can take to minimize conflict. At the end of the day, we do have a good reason to be doing this. These things do genuinely damage public and private lands if we allow them to spread out of control. And by their nature, they spread quickly and aggressively. So this is one of those things that we do need to control for good government type protecting the citizenry reasons. And I think most people understand that when you just talk to them person to person. Mostly, of course. All right. Well, are there any other questions here? Going once, going twice. All right, folks. Well, thank you very much for your time and your attention. I hope it was an interesting or at least a useful subject here. And yeah, Heather, have you got anything else here?
No, we're in the process of printing up new coverage documents. They literally just went over to the printer. We've had a lot of folks
We
come
lost you there.
in. Huh?
We lost you there for a second, or at least I did.
Oh,
Would you mind repeating?
so we just sent new coverage documents over to the printer today for printing. We've had a lot of calls into the office asking, when are we going to get the bill, that kind of a thing. So the coverage will take effect the 1st of July, and the bill will be due the 15th of August, and we will get those out just as soon as they get back. But everyone will remain covered. If you have any questions, just reach out to us here, and we'll get back in touch with you and, hopefully answer any questions that you have. And then next Township Tuesday, I'll, time, prohibiting or time allowing, I will go over some of the, new highlights and stuff like that of the document itself.
All right, folks. Well, with that, thank you very much and have a pleasant Tuesday morning.